Today, for the first time since the Ferguson grand jury decision in the shooting death of unarmed teenager Michael Brown came down, Prosecutor Bob McCulloch is now speaking out. He's defending himself after scrutiny over who he put on the stand. All In has been reporting on problems with the testimony from witness 40 for over a week. That witness said Brown went, quote, running right at the cop like a football player, and many in the media seized on that quote.
Quote, and I'm reading, like a football player with his head down charging. That Michael Brown, was charging like a football player, full force. One witness described it as charging at Officer Wilson like a football player with his head down.
Chris Hayes has been reporting on why that witness's credibility is suspect, as have other journalists. And the grand jury documents show a special problem with this witness. They showed that the investigators knew at the time that her story didn't add up. Today, McCulloch felt compelled to address critics who say he shouldn't have put such a suspect witness on the stand at all. In a 30-minute interview with a St. Louis radio station, he answered a question apparently referring to those problems with witness 40.
There's talk of one witness now, and this was a lady who clearly wasn't present when this occurred. And she recounted the statement that was, right out of the newspaper about, Wilson's actions, and right down the line with Wilson's actions, even though I'm sure she was nowhere near the place.
That is remarkable. The prosecutor saying he knew the person he called as a witness to the incident was not a witness. She wasn't even there. I want to read that quote back. Quote, I'm sure she was nowhere near the place. Now, this was meant to be some kind of explanatory interview for Mr. McCulloch, but it's also a pretty remarkable admission. He's now saying that getting this testimony from people like witness 40, though, this was all part of the official plan.
Well, early on, I decided that anyone who claimed to have witnessed anything was going to be presented to the grand jury.
So anyone who claimed to be a witness got to speak, apparently regardless of evidence that showed they weren't a witness to the killing. And today, McCulloch said he'd be criticized if he didn't let these would-be witnesses testify.
I knew that no matter how I handled this, there'd be criticism of it. And so if I didn't put those witnesses on, then we'd be discussing now why I didn't put those witnesses on, even though, even though their statements were not accurate.
You don't need to be a lawyer to know that doesn't make any sense. It is wrong for a prosecutor to put forward witnesses he believes are lying. And I think it's hard to imagine anyone criticizing him for sticking to only, the reliable witnesses, the ones who were there, the ones who saw the incident. That, after all, is his job. Joining me now, Jonathan Shapiro, a former federal prosecutor and special assistant to former U.S. Attorney General Janet Reno. Good evening to you. I want to mention you're the author of a book, Lawyers, Liars, and the Art of Storytelling. I don't want to talk too much about storytelling with you, but more truth. And why would a prosecutor say that he should put people on the stand in a grand jury that he didn't think were telling the truth?
Well, he shouldn't, and no lawyer should. The rules of professional conduct prohibit it. Rule 3.3 specifically says a lawyer shall not put a witness before a tribunal, including a grand jury, if the lawyer, including a prosecutor, knows the person is not telling the truth. You can't do it. It's illegal. It's called suborning perjury. If you do it, the sanctions that you face are contempt of court, sanctions by your state bar, in this case, the state of Missouri, or prison. You'd be indicted for it. The question is, what did this prosecutor know and when did he know it? If he knew that that witness, number 40, was lying and wasn't there, he had an ethical, legal, and professional duty to not put the witness on the stand. If he found out about it later, he had a separate obligation to notify the tribunal, that is, go into the grand jury and say, that witness lied to you. The idea that you're able to sort of open up the grand jury witness stand to anybody who wants to have a say, like it's a group meeting or something, is outrageous. I've never heard of a prosecutor suggest that that's an appropriate way to handle what is, after all, in the Constitution. By law, our founding fathers said that you cannot be charged with a crime unless you have been indicted by a grand jury or had a public probable cause hearing.
So, Mr. Shapiro, just to be clear, what you're saying is not that this was simply bad lawyering or an incompetent presentation of a case. You are saying, based on the record available, that it could rise to the level of an actual ethical violation or sanctionable offense by this prosecutor.
I go back to well, first of all, again, I say it depends on what he knew and when he knew it. If he knew that the witness he was putting before the grand jury was lying, he had an ethical and legal obligation not to put that witness on the stand. If for no other reason, that he'd be tanking his own case, which raises an interesting question.
Well, and the externally available evidence, that is to say the material they had apart from her own statements, suggested that she wasn't there. The diary entries that she purportedly provided had these bizarre explanations, racially tinged, for why she went to that neighborhood 40 minutes away. She had no other reason to be there. And as we've reported extensively, she also had this history of inserting herself in other cases and has a host of problems that are her problems.
Right.
So it would seem that they knew then.
Which raises all kinds of flags as to why you would put that witness on the stand. If you had serious doubts about this witness, about their credibility, at the very least, you had an obligation, I believe, to notify the grand jurors that this witness came with this baggage. But I have to say, based on the record that we have, I think there are a number of questions that suggest that this prosecutor, and just so we're clear, prosecutors are, by law and by their oath, required to follow the same rules as a criminal defense lawyer or any other attorney.
Right.
If any attorney put a witness before a tribunal knowing that that witness was a liar and didn't tell the judge, they would be guilty, in my opinion, of possibly suborning perjury. Certainly, they should have a contempt hearing, and they should be looked at by their state bar for violation of their ethical obligations.
And those are strong rules that are supposed to be enforced uniformly. I want to mention as well, there are state lawmakers now there in response to this interview calling for a state investigation. Jonathan Shapiro, we thank you for your expertise and your time tonight. And we are going to turn to some better news tonight in an All in America story that's coming up.